earnest money. 840 claims that it is entitled to the money because the appellee breached its obligation to use its obligation under the contract to use its absolute best and most zealous efforts to successfully seek all governmental approvals. It's undisputed that they never even applied for any governmental approvals, that RE Land never even applied for any governmental approvals. This dispute does not involve land. The plaintiff's complaint alleges breach of contract for the defendant's refusal to consent to release of the money. RE Land's brief states, quote, "The entire underlying claim of RE Land is that 840 Development refused to release this earnest money." It goes on to say that RE Land claims this means that the contract has not been terminated. That argument ignores that 840 Development was entitled to the money as its sole remedy for a breach of contract by the appellee. The complaint seeks only a return of the earnest money plus fees and expenses. Despite that, the list pendants filed over 7 months after the complaint falsely asserts that, quote, "the complaint asserts an interest in real estate described in the complaint." The list pendants demonstrates that this dispute does not involve land and that the list pendants is intended to encumber the defendant's property to pay any money judgment which the appellee might receive. The list pendants states, "The complaint seeks the return of earnest money resulting from defendant's breach of contract by refusing to direct an escrow agent to release the plaintiff's $500,000 earnest money deposit. The funds are not sufficient to cover the award of interest, attorney's fees, and expenses incurred by the plaintiff." List pendants cannot be used to preserve funds for a judgment. The Superior Homes mortgage case makes that clear. Now, the plaintiff also claims that it has an equitable interest in the land because there is still a valid and enforceable contract, is their term. This ignores that the contract has both been terminated and is expired. The plaintiff cannot assert a claim in the defendant's real estate. Under the contract, when the plaintiff demanded a return of the earnest money, that became plaintiff's, quote, "sole and exclusive remedy." The defendant's sole remedy was to, quote, "terminate this contract and retain the earnest money as liquidated damages." So 840's claim to the earnest money does not somehow keep the contract from being terminated. That is simply the defendant exercising its sole remedy. If the plaintiff wins, it would not receive any interest in the land. Regardless of who wins, a list pendants will terminate when the trial court enters its final judgment.
Which brings me to a question. What's the status of this case in the trial court?
The status of the case in the trial court is that discovery is ongoing, Your Honor. There's not been a scheduling order or a trial scheduled yet. Discovery is ongoing.
How does this court have jurisdiction?
This court has jurisdiction because the defendant, 840, filed a motion to remove the list pendants because there was no grounds for there to be a list pendants, and that the trial court denied that motion and designated its order as a Rule 54.02 final order.
And why is that? Why is Rule 54.02 applicable here?
Because it left nothing left for the trial court to determine with regard to the separate issue of the list pendants. And the list pendants itself is a separate issue because a list pendants can only be filed as a component of a claim to land. and the claim to land is a separate claim for relief, both in fact and also under the contract. The contract made it very clear they could either file a claim for the earnest money, or they could file a claim for a complaint for specific performance, thus a complaint for the land. So the when a lis pendens is only appropriate if there is an interest claimed in the land, which by filing a lis pendens, then that's a derivative claim of a separate claim to the land, which they didn't file here, but had they, it would have been a separate claim.
So you're saying it's totally independent of what's left in the trial court?
Yes, sir. Yes, sir, that's what we're saying. Because the only fight is over the earnest money. That's all we're fighting over. They never should have filed a lis pendens, because lis pendens can't be filed when you're only fighting over money. Lis pendens can only be filed when the trial court's ruling would affect real property. In Oliver versus Upton, this court stated that a lis pendens terminates when the trial court enters its final judgment. In Oliver versus Upton, this court also stated, "We hold that the trial court erred in ruling that the lis pendens would remain in effect until satisfaction of Oliver's judgment. Once the trial court entered its final judgment, the purpose of the lis pendens, to notify potential purchasers or encumbrances of the pending litigation, no longer existed. Thus, upon the lawsuit's conclusion by a trial court's entry of the final judgment, the lis pendens also terminated." Neal versus Barone found that a lien, quote, "a lien lis pendens is only available wherein the specific property secured is a part of the corpus which constituted the subject matter of the suit. The lien lis pendens preserves the status quo and protects the interest of the litigants in the specific property which is the subject of the lawsuit." Oliver versus Upton also stated that a lien lis pendens is to provide notice of, quote, "a pending action affecting the title or right to possession of the subject property." CJS also states that a suit for money damages only is not appropriate for a lien lis pendens, even if the suit itself relates to real property. TCA 20-3-101 lists the circumstances when a lis pendens is available, and none of those circumstances are present here. Rule of civil...
That's assuming the trial court, or assuming the appellate court has jurisdiction to review that question.
Well, that would be, yes, Your Honor, but the court found that, you know, there's no, nevertheless, there's those statutes. The statute does not allow for a lis pendens in this, because the circumstances under which a lis pendens can be filed are not present.
I'm not arguing with you whether it's right or
Yes,
not. I'm just simply saying, I'm trying to ascertain why this court has jurisdiction to review this appeal at this juncture.
This court has jurisdiction because the trial court properly designated a separate issue, an entirely separate issue, a standalone issue. Is there grounds for a lis pendens as a Rule 54.02 final order?
Well, that happens quite often.
Yes, sir.
How does that square with Nashville Church of Christ versus Amy Grant, filed July 19, 2024? You familiar with that case?
No, sir.
Okay. How about Infinity Homes versus Horizon Land Title, filed, June 8, 2023?
Yes, sir, I am familiar with that one.
Okay.
And in that one, that had nothing to do with the validity of the lien lis pendens itself. The question there was whether the title company had a duty to discover that the lis pendens, discover the lien lis pendens and inform the buyer, Infinity Homes.
Well, let me ask you about another case.
Yes, sir.
Christus Gardens versus Baker Donaldson, filed July 17, 2008.
Yes, sir.
Aren't these claims interrelated?
No, sir. No, sir, because here
Aren't we dealing with a contract
We are dealing with a contract.
to sell real estate?
We're dealing with a contract to sell real estate, but
And doesn't this all arise out of a contract to sell real estate?
this arises out of a contract to sell real estate. But now,
How does that differ from Christus Gardens?
because in Christus Gardens, there wasn't a exclusive remedy that allowed them only to seek a claim for the earnest money, which is what the sole remedy is here. If RE Land had chosen to file a claim for specific performance, certainly they could have had a lienless pendens, but that's not what they've done. The only thing they're fighting over now, the only thing they're seeking is $500,000 in earnest money, which is safely in the custody of the court clerk. And so therefore, the subject matter of this lawsuit is not the earnest money. The subject matter of this lawsuit is not the land. The subject matter of this lawsuit is only the earnest money, which Rule 69.07 states, a lienless pendens applies only to realty that is the subject matter of this lawsuit and described in the complaint. I mean, it's almost a catch-22, Your Honor. I mean, what they're saying essentially is, well, we only could have filed, they're saying essentially we can only file a claim, by not having filed a claim for the real estate, they don't have grounds to file a lienless pendens. The claim for the real estate would clearly be an entirely separate claim.
Well, you've got 3 minutes of rebuttal time, and when you come back up on rebuttal, I want you to explain to me what were the reasons that the trial court found that there was no just reason for delay.
I will do that, Your Honor.
Thank you. Hear from the appellee.
Good afternoon, Your Honors.
Good afternoon.
My name is Garrett Anglin, and I and my co-counsel, Gilbert Anglin, represent the appellees in this matter. Just for the brief background, appellant is correct that there are competing breach of contract actions pending in the trial court at this very moment. Those breach of contract actions concern a contract for the sale of real property, specifically the appellant's real property. Now, I believe that appellant is slightly misstating what the issue is in the trial court and what the pending action is. This is not a dispute over money. This is not a dispute over earnest money. It is a dispute in the trial court over the obligations and liabilities of parties under that contract for the sale of real property. And in the trial court, at multiple hearings on motions to quash this lienless pendens, which was filed by appellee for the purpose of preserving the status quo of the parties under that contract until the trial court could render a final determination of the obligations and liabilities of the parties under that contract. At multiple hearings, appellant admitted that when you sign a contract, the purchaser has an equitable interest at that time. And the court at multiple points asked whether both parties now are relieved of any further obligations or liabilities under this contract, to which counsel responded, that's what the whole lawsuit is about. And that's what this whole lawsuit is about. The merits of the claim have to do with the interpretation of the contract and the determination of the obligations and the liabilities of the parties under this contract. And that is irrelevant to a determination of the lienless pendens. And there are three paramount issues here. There are three issues bearing down on this appeal that I want to address sequentially. The first one, obviously, is the most paramount, and that is whether or not the order that has been appealed from was properly certified as final under Rule 5402. And of course, it's most paramount because that would render the appellate court having a lack of subject matter jurisdiction in this matter. Now, this court has set out two requirements for the proper certification of a final order under Rule 5402. The order must eliminate one or more but fewer than all of the claims or parties, and two, the order must direct entry of the final judgment upon an express finding of no just reason for delay. Those are the two factors that have to be fulfilled. And the main issue is that this is not a separate claim. The lienless pendens is not a separate claim from the underlying breach of contract action. It is a notice of a claim. And by its very terms, it is simply a notice to future purchasers or potential encumbrances of that land that there is a pending litigation in the trial court concerning a contract for the sale of real property, and that contract could affect title to that land. And a claim is defined by this court as the aggregate of operative facts which give rise to a right enforceable in the courts. That definition is important because it is not the right enforceable in the courts that makes it a claim, it is the aggregate of operative facts. And many courts that we have cited in our brief actually look to what that aggregate of operative facts is. We cited cases where the courts acknowledge that a plaintiff may file a complaint for multiple causes of action, but determined that the aggregate of operative facts makes all of those theories for relief one claim. So, for example, in Paul v. Watson, the plaintiff had filed a complaint with causes of action for conversion, misrepresentation, violation of the Tennessee Consumer Protection Act, breach of contract, and there was an order that was certified as final that had not dealt with the conversion and misrepresentation theories for relief. And in that case, the court said that the crux of the case involves an alleged oral contract and the alleged breach of that contract. And because all of the theories of relief that were seeking that claim, that were pursuing that claim had not been resolved, the order was not properly determined to be final, and the Court of Appeals did not have subject matter jurisdiction for review of this matter. And the exact same principle applies in this case. The claim for breach of contract and the lien less pendants involve a single aggregate of operative facts. As Your Honor, I believe, may have been intimating, it's a single aggregate of operative facts. It's a breach of contract action. They're all intertwined with this claim of breach of contract and what the obligations and liabilities of the parties are under that contract. The claim for breach of contract and the notice arise out of the same transaction, the contract. And in fact, even more so than a separate theory for relief such as misrepresentation or conversion, because the notice less pendants is not in and of itself an enforceable theory in the court. It cannot be pursued independently. Moreover, this court has never ruled, at least none that we could find, has never ruled that a lien less pendants is appealable prior to a decision on the merits. However, the Middle Eastern and Western U.S. District Courts of Tennessee have all ruled that a lien less pendants is not appealable prior to a decision on the merits. And the reason for that is quite clear. As the court notes, a less pendants terminates upon the conclusion of the underlying lawsuit. Once the trial court enters its final judgment, the purpose of the less pendants to notify potential purchasers and encumbrances of the pending litigation no longer exists. And based on this, and this was Domus Development LLC, which was the U.S. District Court for the Middle District of Tennessee. And based on this analysis, the court stated, in the court's view, the relevant question is not the strength of plaintiff's claims to the property or whether plaintiff's lien less pendants complies with Section 101A, but rather the pendency of this action. And both the Western and Eastern Districts of Tennessee upheld this exact ruling, one in Munson Hardesty v. Legacy Point Apartments, and the other Holbrook v. Ownbrooks International Corporation. And the reasoning is logical, because the notice less pendants is a notice of pending litigation. It is not its own claim. It cannot be ruled upon and appealed and determined separately from the underlying action. In fact, once the underlying action is determined, the less pendants terminates as well. In the present case, the trial court has ruled that there are rights and obligations under that contract that have yet to be decided. The notice less pendants is nothing more than an additional remedy to preserve the status quo while those rights and obligations under that contract are determined by the trial court. At this point in the proceedings, this is effectively an appeal that we're not reviewing the merits of the case. The trial court has not reviewed the merits of the case and made its determination. So it would not be appropriate for the appeals court to make a determination in step to reviewing those merits prior to the trial court. If the court were to consider a less pendants a separate claim, it would also render absurd results. For example, a plaintiff could file an action seeking solely to file a lien less pendants, and then as soon as the court granted it, the lien less pendants would terminate by law because the underlying lawsuit had now terminated. Obviously, that's not what the courts or the legislature intended for a lien less pendants to do, because again, it serves as a notice of a claim and not its own claim itself. Also, appellant raises the choice of remedy as its main argument, that we are seeking the return of earnest money rather than seeking specific performance under the contract as a reason why A, it's its own claim, and B, that it's a valid lien-less pendens. In both scenarios, the choice of remedy has no relevance, right? Because it's not the choice of remedy that renders rights to RE land in the property, it is the contract itself. And as the court has already noted, there are rights and obligations under this contract that still have to be decided. So all the lien-less pendens is doing is preserving that status quo until such a decision can be made. Now, the other factor for Rule 54 certification is that the order has to show that there is no just cause for delay. Now, the Tennessee Court of Appeals has laid out numerous factors in determining whether there is no just cause for delay and certifying an issue as proper. Now, if you review the order, the court conducted no analysis of these factors whatsoever, other than stating very simply, there's no just cause for delay. And as Tennessee courts have noted, dismissal is proper if the trial court reveals a failure to weigh and examine the competing factors involved in the certification decision. Even more, if the appellate court were to weigh these factors itself. The factors cited by Tennessee courts disfavor review. One, the lien-less pendens is inextricably linked to the underlying breach of contract action. Two, the need for review would be mooted by future developments in the trial court because the lien-less pendens itself terminates by law once the breach of contract action has been decided. And three, the underlying breach of contract action will inevitably have to be heard, so there is no expense or delay avoided by the appellate court deciding to rule upon this issue now rather than at the end of the case when a final decision has been made on the merits. And because of that, both factors have not been met for a proper Rule 54 certification, meaning that at this stage it would be inappropriate for the appellate court to review this. Now, the alternative is for the appellate court to convert this into a Rule 9 interlocutory appeal.
Is that even possible?
It is possible, but under very limited circumstances. The courts have made clear that a conversion must require some showing that the issue is worthy to be heard as an exception to the normal rule of deciding cases only after a final judgment. And the rule of deciding cases after a final judgment is a bright line rule. Appellate courts do not want piecemeal litigation. They do not want to make decisions in the middle of an action. They would rather do it with finality. That is what they want to do. For example, in the case of Town of Collierville, which was actually cited by the appellants, the court pointed to, this was a condemnation action that was occurring. And the court had pointed to hazardous conditions and safety concerns, which the court felt compelled them to go ahead and render a decision in that matter so as to go ahead and push the action along. And we have no showing at this point in this case that there's any reason for an exception to the bright line rule that this matter should be heard after a final decision has been made on the merits. And furthermore, there is no indication that the trial court seeks guidance on this issue prior to proceeding to a trial on the merits. In fact, there really isn't any basis at all. So effectively, we would submit that the appellate court should acknowledge that there is not a proper Rule 54 certification and dismiss the appeal based on a lack of subject matter jurisdiction. However, even if the trial court decides to proceed, if it says we'll set aside the improper certification, we'll convert it to a Rule 9, and we're going to go ahead and hear this appeal, even if it does address this on its merits, the lien-less pendens is valid. As appellant cited Neal v. Barone in the Tennessee Court of Appeals from 2010, a lien-less pendens is appropriate to preserve for judgment real property which is the subject of the litigation and may not be used to secure property for judgment in a case unrelated to real property. It is undeniable that this case is related to real property. It is quite literally a dispute over a contract for property's sale. And the court has noted that, the trial court has noted that time and time again, that we have a breach of contract action pertaining strictly to real property, and the rights and obligations of the parties under that contract have yet to be decided by the trial court.
You're not seeking specific performance, are you?
We are not seeking specific performance at this time, but that right has not been taken away from us under the contract.
So you're not, it's not been pled, has it?
It has not been pled.
What's the purpose of the lienless pendants? I mean, the money is in court. Well, I'm just trying to understand what the purpose of it is.
The purpose of the lienless pendants is to ensure that the rights and obligations of the parties, that the status quo of the parties under the contract is preserved. And the contract creates an equitable interest in the property, which can't simply be taken away because of the choice of remedy that's been pled in the complaint.
But if you're just seeking damages, you're seeking the $500,000 that's been paid into court, and you're not seeking specific performance, then I'm not sure what purpose I see in the list pendants.
Well, that's true, Your Honor. We are not seeking it now, but the right is not foreclosed to us, which is not correct to say that simply because we have pled initially that we are seeking a return of the earnest money, that the circumstances in this litigation could change, that we would seek specific performance, which would be a right that would be foreclosed if the lienless pendants were to be dissolved. And so that's another status quo that's being preserved at this point in the litigation because the full obligations and liabilities have not yet been determined. And there could be a point in the litigation where a need to either reach out to seek possession of that property, either party could change the circumstances of the case. But again, we're trying to preserve that property from being sold away during the pendency of this action when there is a contract that is still in play that could affect the title of that property.
But you're not seeking any interest in the property, you're just seeking money.
We're seeking to enforce a contract that creates interest in that property, and that contract is still being decided by the trial court.
What interest in the property are you seeking? What have you pled? What interest have you pled that you're seeking in the property?
Well, we have a contract that creates an interest in that property. That contract is still being enforced by being interpreted by the trial court.
Are you seeking anything other than money?
At this point, we have not pled that we are seeking title to the land. That is correct. But that does not take away the fact that the lienless pendants is valid legally, because it's not a determination from either the trial court or the appellate court as to whether or not what damage is being sought, but it's the contract itself that is being preserved, and the status quo is being preserved until the final determination is made on the merits.
Is that not the purpose of the earnest money?
The purpose of the earnest money doesn't cover any other further damages that could be determined under the, for example, costs or attorney's fees are also contemplated under the contract. The contract creates an interest of the parties in that property, and the earnest money itself doesn't deal with those other aspects.
Well, that sounds like that you're using the list pendants to protect any further interest that you may have as far as money is concerned, to secure an additional money judgment. Is that what you have the list pendants for?
That's not the purpose of it. The purpose of it is to preserve the status quo, because there hasn't been a determination as to all of the rights under this contract, and that the parties shouldn't be able to go out and sell the property and move the property around while this pending contract action is ongoing.
Thank you.
Thank you, Your Honors.
So the court's finding of no just cause for delay, the trial court's finding, can be overturned only by a finding of abuse of discretion. And the trial court clearly did not abuse its discretion in making that finding.
Well, what reason did the trial court give for finding that there was no just reason for delay?
The trial court did not state a reason in its order for that finding, nor is the trial court required to do so, though it's preferable.
I believe you may be incorrect in that. There's a case that was filed, August 2, 2024. Ethan Rashid Holmes, as the surviving child and next of kin of Ephraim Holmes versus Stacy Ship, 2023-00605, where Judge McGee states totally to the contrary.
So, you know,
That if the trial court is required to make a finding and to support that with its reasons.
so at the time the trial court entered its ruling, at the time we briefed this matter, apparently until within the last couple of weeks, there was no requirement that the trial court make a specific finding of that, as long as the record supported the trial court's finding. And here, there
That's
are
odd
facts.
because she's citing to cases from 2014 and 2015, or excuse me, 2016, and those seem to predate the order of the trial court.
So there is authority cited in the brief and in the reply brief that we have filed that a trial court is not required to make specific findings.
Let me read this to you.
Yes, sir.
Although the trial court's summary judgment order disposed of the claims against one party, we conclude that the trial court erred in finding that there was no just reason for delay. This court has adopted from the federal jurisprudence a list of factors that a trial court should consider in deciding whether or not to certify an interlocutory judgment as final under Rule 54.02. Cites the Coleman case from 2016. These factors include the relationship between the adjudicated and unadjudicated claims, the possibility that the need for review might or might not be mooted by future developments in the district court, the possibility that the reviewing court might be obliged to consider the same issue a second time, the presence or absence of a claim or counterclaim which could result in set-off against the judgment sought to be made final, and miscellaneous factors such as delay, economic and solvency considerations, shortening the time of trial, frivolity of comparing claims, expense, and the like. Again, quoting a 2014 case. Although trial courts have considerable discretion in making the determination that there's no just reason to delay, appellate review, such a determination is subject to reversal if the court fails to weigh and examine the competing factors involved in the certification decision.
Here, I think the record is clear that the trial court knew that there was a $12.6 million property that was encumbered, and that the interests of justice require appellate review of that matter. Of course, alternatively, we would also, as we asked in our brief, ask that the court consider this as a Rule 9 appeal by permission. The court made it very clear that it was allowing this appeal to go forward.
Let me ask you.
Yes, sir.
I think it's pretty clear under the case law that a lienless pendants is not a claim such that you can file an appeal.
Yes, sir.
But in this case, this lawsuit got started because the other side filed a breach of contract claim because you refused to return the earnest money because they couldn't get the permit they were seeking.
Yes, sir.
And you refused to return it. They filed a lienless pendants. And now you want that quashed. Why?
Because the breach that the plaintiff made was the plaintiff had an obligation to use its absolute best and most zealous efforts to obtain all governmental approvals that it needed to do its project. That was the absolute best and most zealous efforts language is directly from the contract, Your Honor.
But you can litigate all of that in this pending litigation about whether or not they breached or whether your client breached.
Yes, sir. That we will, and that we are litigating.
That's still in the trial court, correct?
Yes, Your Honor.
All those issues are yet to be determined.
That is correct. But if the plaintiff, and this is what gets back to what was being discussed earlier, if the plaintiff wins, if the plaintiff gets an absolute and total victory, what does the plaintiff...
Which means they've shown that you breached. That's the only way they win.
Yes, sir.
Okay.
Yes, sir. And if the plaintiff wins, if they have an absolute and total victory, what do they get? They get the $500,000. They don't get any interest in the real property. Therefore, this claim, this suit does not affect real property, and therefore it's not appropriate for a claim for a lienless pendens. A lienless pendens is only appropriate when the trial court's ruling would affect real property, when the real property is part of the subject matter is part of the corpus of the suit. It's not here. And so there's no claim to the real property, and since there's no claim to the real property, then there can't be a lienless pendens. It's appropriate for Rule 54.02 because a claim to the real property would be a completely separate claim from a claim to the earnest money.
Well, 5402 doesn't apply unless you have a claim. This is not a claim.
It's effectively a derivative claim, Your Honor.
It's not a claim at all. It's
So-
a lienless pendens.
You're correct, but it would be derivative only of a separate claim, a claim they've not filed, and therefore they don't have grounds for the lienless pendens. It gets into kind of a catch-22, so almost chasing our tail, Your Honor.
Okay.
All right, thank you, gentlemen. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. You may be excused. We're going to take a brief recess, and the next case can move up to the tables, and we'll be back in just a moment and commence hearing it.
All right.